What is an additional procedure if that's not the right fit for a potential client?
So there's definitely, you could do mediation or a collaborative divorce. Some counties are all going to pretty much be private mediation. They're still going to order it, but it's going to be private.
And that's something that the client can opt into. If we're already going to be going to court-ordered mediation as a part of this case, why not go to a mediator that can address it all and see if we can do a global agreement versus piecemealing things?
So I'm actually on the other side of that.
Okay.
I like private mediators, especially for child-related issues. I do not like private mediation for financials.
And why? All right, welcome to the podcast. I'm Katie VanDeusen. I'm the managing partner at Sterling Hughes, and today I have partner Nina Kelly with me, joining me on the podcast.
Hello.
So Nina, today we are going to be talking through kind of the initial divorce process and some options that people may not really be aware of. When it comes to divorce, what are some of the first steps you take when talking to a potential client about what options exist for them?
So the first one I usually talk through is the easiest, it's the most efficient, it's usually the most cost effective, and that's like an uncontested or an amicable divorce. If you have two people that kind of, already agree on maybe not every little detail, but like big picture, they're not worried about somebody hiding money, they're not worried about, any child related abuse issues or, any reason to restrict parenting time, that type of thing. And they're pretty much on the same page with respect to all of the terms, then an amicable or an uncontested divorce is definitely the easiest way to do it. There's a couple different, there's not only one way to do it, but typically the process would be to kind of make sure you talk to them about what their agreement is and then draft it and kind of circulate. Have you found that that's kind of what you do too, as far as the process of talking to your client first? I like to see if they've already spoken to the other party, and then drafting it up before sending it over to them.
Definitely. I try to do that even prior sometimes to filing any initial paperwork to try to really test and see, do these parties actually agree on all of the legal issues that are involved or included in the divorce?
Right.
One follow-up question I have. So in your experience, Nina, at the firm, about how long does it take from start to finish for that kind of uncontested divorce process?
So, let me know if your experience has been different, but I've literally done a divorce in like 22 days, I think is my record. That obviously is not, that was very short. Usually I'll talk to a client. It'll take me a couple weeks to draft the agreement or agreements if there's kids. I'll send it back. We'll probably go back and forth over a couple weeks, then send it to the other party. And then it really just depends on, are they in agreement or not? It could be done then, or, it could take some additional time.
I totally agree. I think my average, I would say, is maybe anywhere from 60 days. I think that's my target, really. There have definitely been examples where it's been shorter, and there have definitely been examples where it's taken a little bit longer, maybe if there's a more complex estate or maybe more complicated child-related issues. But I think 60 has been kind of my average overall.
Yeah, especially if it's truly uncontested. I would add too, some people, court gets a bad rap as far as sometimes taking long procedurally. So people are afraid, even if they have a full agreement, well, are we not going to get into court for 6 months or something? But if it's an uncontested, fully agreed upon, usually the judge can get you in between like 1 to 4 weeks.
Do you find that certain counties are easier to process those types of cases, or do you feel like all of the counties we practice in are about the same in terms of processing?
Frankly, I feel like they're kind of the same. Some are more difficult as far as like nitpicky procedural little items that the client doesn't have to worry about, just the attorney kind of has to worry about making sure are done. But as far as like the ease of doing it, I think they're kind of about the same. Would you say that?
I would too. I think that, of course, there are going to be those like nuanced forms in certain counties where maybe there's 1 or 2 additional steps you have to take.
Right.
I think the one other thing that I would bring up that I think a lot of people don't always remember is that parenting class. Do you want to talk about that? That's like, I feel like sometimes one of the biggest delays in processing uncontested
I've
case.
had people, I've had final like, settlement totally signed. In fact, frankly, kind of recently, and it delayed it 2 months because both of them were just kind of like, oh, I'm going to do it. Especially now that some judges are doing in person. Although I will say, for uncontested cases, I have been telling people to do the online course, and I haven't been rejected yet. As far as in Cook County, yeah, but I try to send the parenting class early on. So those, I mean, the sooner the better. Although the problem with the parenting class in uncontested cases is you have to have a case number. So you can only, get so ahead of it, because I don't like to file a case before we have signed agreements, because if it's not going to be uncontested, the case is going to look a lot different, which means the fees look a lot different and the process looks a lot different. So that's definitely kind of a hindrance.
So, in that vein, let's kind of talk about that. So,
Yeah.
if you, in terms of options, we've talked through this kind of uncontested option. What's another option, or what is an additional procedure if that's not the right fit for a potential client?
So, I mean, there's definitely, you could do mediation,
Okay.
or a collaborative divorce. I know you have a lot of experience doing those too, because you're certified, right?
Yes. So I do mediation and collaborative. So let's kind of break down mediation and talking about that as an option. So, when it comes to mediation, I think sometimes people have a tendency to get it confused because there's a difference between court ordered mediation and
Mhm.
private mediation. Do you kind of want to talk through those differences, Nina, and kind of identify them?
Yeah, yeah. So court ordered me when you have kids in Illinois and you're getting divorced, the judge almost always, there has to be good cause shown of why to not go to mediation. Otherwise, the judge is going to send you to mediation if there's not an agreement on the child related issues. And I think we'll probably touch on that in a different session. But the issues are as far as parenting time and decision making. If that's not agreed upon right away, and I will say, I don't know if you do this, Katie, but I send a proposal right off the bat if there's kids, especially in a contested and uncontested. I send a proposal for the parenting terms right away to see if we
Same.
need mediation or not. Right,
Yeah,
like a high
absolutely.
level bullet, like boom, boom, boom. Here's what we're thinking. How, and if we're really far apart, then the judge will go to mediation.
The only time frame, Nina, where I would say I haven't done that in like actual practice is if there's any kind of like emergency issues or
Yeah.
if there's safety concerns, then I may end up kind of going the route of filing some type of emergency motion or asking that a guardian ad litem be appointed right away. But you're kind of leapfrogging that step procedurally if you're doing that. So, it's always important to kind of stress to the client and set expectations in terms of we can try to kind of leapfrog this court ordered mediation step, but it may not always work. It just is so fact intensive and fact specific. It's kind of hard to determine whether or not that's going to happen.
Right. I
So,
mean, the only way it really, I've never had it not happen is if there is an order of protection. Then they won't do it. They won't take it. But otherwise, so that's the court ordered mediation will be if there's child related issues, the judge is going to order it, right?
yep.
Um, and then
And
the other,
what does the mediator focus in on in that court ordered process, Nina?
so they are just focusing on the allocation of parental responsibilities, or what used to be called custody, right? They're going to try to figure out, and frankly, I get sometimes frustrated. I don't know if you get frustrated, Katie, with the mediator, because they'll focus on like the Christmas time schedule and like the tiniest little things. And they'll come back and my client's like, well, we agreed on this. And I was like, yeah, that's great. But we were going to agree on that anyway. Like, what about parenting time? And they're like, well, we didn't agree on that. And I'm like, okay. But I think they do try to kind of grease the wheels a little bit and start to get some agreements to hope it leads to bigger agreements. But yeah, just those two things.
And then what do you mean by allocation of parental responsibilities? What does that cover?
So people come to me. I don't know if this happens to you, Katie, but pretty much every single client comes to me saying, I want custody. I want them to have visitation, something like that.
Yep.
And those terms are just outdated. We've just kind of rebranded. I mean, it kind of breaks down to it's the same concepts, but it's a little bit different because now it's called decision making for the big four things. That's education, healthcare, religion, and extracurriculars. Who's going to make those decisions, and if it's going to be joint, and then the parenting time schedule, on a week to week basis, but then also vacation time, holiday time, stuff like that too.
Yeah.
Um, so that's what they're going to be focusing on the court ordered mediation. Although I will say, because I feel like this isn't very well known either, Katie, is that some counties are all going to pretty much be private mediation. They're still going to order it, but it's going to be private.
Yep.
Um,
And that's something that the client can opt into, right? Or
right.
that's a discussion maybe you as the attorney are having with the client to say, listen, if we're already going to be going to court ordered mediation as a part of this case, why not go to a mediator that can address it all and see if we
Yeah.
can get a global agreement versus piecemealing things?
So I'm actually on the other side of that. Which
Okay.
most attorneys are not. I like private mediators for child related issues. I do not like private mediation for financials.
And why?
If parties are represented, if parties are planning on being, because there's a way to get divorced without ever hiring an attorney, I would never recommend it because then end up coming back later because they messed something up or something's not detailed enough. Like there's a reason there's divorce attorneys. But if you're going to do it that way, then a mediator, sure, can help you, guide you, give some ideas. But Katie, I have never had a case where they've gone to financial mediation and that was that. Like it usually takes months and months. It's expensive, and then they tell the proposal to their attorney, and or like I've had a client come to me saying this is the idea, and I'm like, yeah, no, you're not doing that. Like,
Best interest.
right, because the mediator's not telling them what's in their best interest, and so then they just burned a bunch of time. So I usually end up telling clients not to do mediation. Sometimes they do anyway, but when you have attorneys, I do think negotiating through attorneys is better. Do you not find that? Because I feel like most attorneys kind of like mediation.
Well, so it's like a very fine line in my experience. So anytime I'm talking to someone about mediation as an option, I'm always telling them that they need representation on the side to counsel and to figure out what the issues are. Should they agree to something? Should they not? Is it reasonable? Is it not? So I don't think I would ever suggest private mediation without having some type of representation on the side, talking through the client, that process, what it looks like, the legal issues, giving them that kind of frame of reference. Because the mediator, as a private mediator or even a court ordered mediator, you are never to give any type of legal advice to a party that's involved in mediation. So it's a very different role. And I think it's really important that the clients or parties, like the client that you're either speaking to and representing, or the parties that initiate and engage in that, really understand that distinction, because the private mediator or the court ordered mediator is never going to say, here's what you could be entitled to. Here's what the statutes say, and here are your rights. Here's what I feel you could, ask a judge for. They're going to be much more high level. Here are the issues. Let's talk and try to work out an agreement as it relates to all of these individual issues. But they really never are to cross that line. And that's something I think is very important that the attorney kind of lays out for that potential client on the front end.
Right.
Um,
I've
and then
also seen mediators that are not attorneys, because you don't have to be an attorney to be a mediator, which kind of blows my mind too. But then they'll draft like a memorandum of understanding, essentially like the full agreement, and it's like it leaves out. And then the parties, I've had someone come to me like, okay, can you just put this into a marital settlement agreement? And it's like they leave out so many details. Some of it like isn't even legally enforceable. So you really do have an attorney to at least consult with before you would put anything in final writing. That's
well,
kind of why I don't like it. But again, I know I'm in the minority here. I just do not like financial mediation. For parenting, I think it works wonders.
yep.
But
One other thing to keep in mind too, Nina, I think that people don't always think of is attorney assisted mediation too.
right,
Is a great option where, listen, if both parties really want to have that kind of advocacy, that type of legal guidance within the actual mediation sessions, you can always consider that as well. Each side has their own attorney actively engaged in that mediation process. I think it's a good option when you're trying to avoid costly litigation that's going to take a long time, and just, I try everything in my mind to consider alternative options to that. Um, One other option, is collaborative, right? So collaborative is something where both sides are represented by collaboratively trained attorneys. And it's almost like a team approach to divorce, where you can also engage other neutral professionals to help guide the parties and think outside the box. I really do think that is something that is an option for people when, again, they want to avoid litigation. But let's talk about litigation. Tell me a little bit about your experience and what that process is like as an option we give people.
Yeah. So I think, frankly, a lot of people come into it without having discussed the terms and they're like, oh, well, it's going to be uncontested. And I would love to give them the benefit of the doubt, but in my head, I'm always like, okay, probably it's not. Like if you haven't talked about it and you don't, especially if they don't know what the other person has, I have to kind of clarify, like, listen, this is not what's called an uncontested case. So we are going to technically start litigating, meaning I'm going to file a petition for dissolution, either get them served, or oftentimes I just like email it to them and ask them to file their appearance voluntarily. And we're going to start exchanging financial information. But that doesn't mean people oftentimes like interchange like litigation with like being very combative. Or something like that, but it doesn't have to be. The goal is still to settle the case, right? Like 6 or 7% of cases are settled. So just because we start litigating doesn't mean you're in for this enormous battle, but it means you don't have a full agreement. You might not have the full picture. Maybe you need some help on getting some more information or maybe negotiating a few points. That's kind of where it always starts. I always, like I said, kind of send a parenting plan proposal if they have kids. And if they don't, I mean, just exchange financial affidavits the sooner the better, because you can't really do anything without a full financial picture. I really push that early on, which a lot of attorneys don't, but I know here at Sterling, we are very proactive about that.
Definitely. That's great, Nina. Well, I think we're at the end of our podcast. Thanks so much for joining me, Nina, and talking through the divorce process, different options that exist for people so that we can kind of get clarity and give them that information up front. So
My
thanks
pleasure. Thanks for having me.
Knowing your divorce options is powerful, but when it comes to actually filing in Illinois, there are critical steps you cannot afford to miss. Find out exactly how it works in this next video.